All right, welcome everyone. Let's go ahead and get started here. I believe it's now 3 p.m. my time, so I'm really excited to be able to present to you all today on the topic of Ohio legalizing marijuana recreational use for adults. Mute my other speaker there. Hopefully you're all able to hear me okay. If you could please let me know in that chat box if you're unable to hear me, just so we can make sure the quality is working out well for everyone. Give it just a couple more moments for everyone to come in today. All right. All right, sounds like everyone's able to hear me, so let's go ahead and get started here. Again, thank you all for joining me today on this first ever Employment Law After Hours live stream brought to you by Brennan Manna and Diamond. We're here today to discuss Ohio legalizing marijuana recreational use for all adults 21 and over. That actually went into effect today. So given that this is a live stream, I intended it to be a little more interactive between you all in the chat and kind of able to answer your general questions that you may have, not specific legal ones, but just general ones that you may have. I also have a presentation I'll run through so we can kind of discuss where things are at right now as things stand today, or the first day of legalization, where we expect things to go from here, and more importantly, and the actual topic of today's presentation, how does this impact employers? What rights are employers still going to have? What rights are employees going to have still in the workplace? Obviously, there's a lot of gray area that still exists. There's a lot of questions that still remain. So we're going to spend some time today discussing those. I guess just to get started, we'll just jump into this presentation right here. Okay. So obviously, Ohio marijuana in the workplace. Just quick disclaimer, since I am an attorney, we are lawyers, but we're not your lawyers necessarily. And if we happen to be your lawyer and you're on this stream today, please do not ask any specific legal questions. We can talk offline. And if we're not your lawyers and you have a specific legal question that we might be able to help you with, feel free to reach out to me either as a chat message through YouTube or my contact information should be contained at the end of this presentation. You can use that to reach out to me as well. But again, we're not discussing specific legal questions here, just things in generality, hypotheticals, things like that. So marijuana in Ohio, where do things stand now? So as I said, and as probably I'm sure most people in Ohio are now aware, given all the recent news coverage, recreational use of marijuana for those 21 and over is now legal effective today. So what that means is people can possess 2.5 ounces or less legally of different cannabis products. They can use different cannabis products in the privacy of their own home, not out in public necessarily, but in the privacy of their own homes. And that's really where things stand. Eventually, we're not there yet, but eventually, people 21 and over will be able to go to recreational storefronts to purchase marijuana. So fun little fact there. Right now they're expecting it to be about 8 to 9 months before those recreational storefronts actually open up. Obviously, so those of you in the presentation today might be wondering, well, how do we procure the marijuana in the interim? Well, that's kind of an issue for people to decide individually, I suppose. But in terms of recreational purchases in Ohio, which will be legal as well, we're looking at another 8 to 9 months. Now, kind of quick insider tip here, the Senate yesterday actually just passed and sent to the governor's office, or sent to the House rather, a bill that would allow for recreational purposes through the existing medical marijuana storefronts in as little as 90 days, assuming that goes into effect. So the Senate passed that last night. It's got to go over to the House for their consideration. If the House approves that measure, it goes to the governor for signature. You could be looking at recreational purposes in about 90 days. So more importantly, as we're going to discuss here today, how does this impact employers? How quickly do you need to move to amend your workplace policies, things like that? But one other quick caveat before we get into the employer side of things, and it's important to have a lay of the land here, is medical marijuana is not yet changing, or has not yet changed under these statutes. So people that have medical marijuana cards are still able to go to medical marijuana storefronts, purchase their medical marijuana. Nothing's changing in that regard. Similarly, nothing in this issue 2 or in the proposed regs that are coming about through, the speaker, through the House or through the Senate and the governor are going to impact medical marijuana. And there's not going to add any protections for the use of medical marijuana by employees. So again, something we're going to get to here in a moment. So right now, in terms of what employer rights still remain in Ohio, under Ohio law, employers are not required to permit or accommodate the use of marijuana by their employees. So what this essentially means is issue 2 and the proposed legislation from the Ohio government in no way is going to impact the ability of an employer to refuse to hire someone who tests positive for marijuana, or to fire someone who uses marijuana and they discover they use marijuana, such as through drug testing, or rather, even if in Ohio you could be terminated for speaking in support of marijuana legalization. Ohio is an at-will employment state, which means you can be terminated for any reason as long as that reason is not discriminatory towards a protected class. So you could be terminated for coming into work 5 minutes late. You could be terminated for wearing the wrong shirt color. You could be terminated for vocalizing your support of marijuana legalization. So that's just those 3 important caveats that those employers are still going to be able to retain that right. I don't expect too many employers are going to necessarily terminate employees for vocalizing support of marijuana legalization, but that right does remain. Again, in terms of where do we expect employers to go in terms of whether they're actually going to refuse to hire or whether they're actually going to fire marijuana users, we're really not 100% sure. Again, it's up to the employers. I suspect that most employers will take a quote-unquote don't ask, don't tell approach to marijuana, probably similar to what's been in existence for many employers thus far, which just means like, look, we're quietly going to stop testing for this, or we don't care if you test positive for marijuana, but we don't want you to be under the influence at work. What you do in your spare time is what you do in your spare time, but don't bring it to work. Don't consume it at work. Don't be under the influence at work. Things like that. Now, there's obviously a couple caveats for positions there, depending, right? If you are a Department of Transportation licensed position, or you have other, such as maybe you work with or transport children, or you are operating heavy machinery, those positions and those employers may obviously, enact similar restrictions on marijuana, such as what they do with alcohol, right? That if an incident were to occur, they're obviously going to test, and if you test positive, that it could impact your rights for workers' compensation coverage, as well as if they may end up still testing to hire for that position, or they may still end up conducting random drug tests for people in those positions just because of the added risks of those job duties. So none of that changes again under issue 2 or the proposed regulations that and statutes that are being proposed right now by the House and Senate. Maybe we'll come back here towards the end and discuss what some other states are doing. It might give us a little bit of a precursor, a little bit of an idea of where things might go in the future in Ohio. So again, what if you're an employer on the presentation today, you might be asking yourself, what do you do if an employee has a medical marijuana card? So again, medical marijuana, nothing is changing in that regard. And so therefore, the status quo with medical marijuana use and having a medical marijuana card and using medical marijuana product is not protected in the workforce, similar to recreational. Employers are not required to accommodate disabled employees' use of marijuana, even if it's prescribed medically. Similarly, you can be terminated. An employer could refuse to hire you as a result of medical use of marijuana. And that's just a creature of what was built into the medical marijuana statute that was previously passed, as well as the fact that marijuana remains illegal at the federal level. So what do I mean by that? Well, essentially what we're saying here is because medical marijuana remains illegal, you're not going to necessarily have those protections or legalization such as in the medical field that kind of wash downstream down into the states, right? So if in the future, let's say Biden in the next year decides to declassify or lower the classification of marijuana to the extent he's able to, or if Congress were to enact such measures, you might begin to see then medical marijuana protected as an accommodation under the Americans with Disabilities Act. So what do I mean by that? If you have an employee who is prescribed medical marijuana in treatment of their disability, the ADA may step in and say, well, hey, now the employer is going to need to do a reasonable accommodation analysis to determine whether they can reasonably accommodate that employee's use of medical marijuana in the treatment of that disability, similar to what you would do with prescribed Schedule II painkillers or other potential medication that can alter either physical attributes or mental attributes. So again, that could change to the extent that there's this declassification at the federal level, but we're not there yet. We haven't seen that yet. We're not sure necessarily what Biden or Congress are going to do over the next year. I suspect Biden may try to do something in the next year, at least in terms of maybe lowering the classification of cannabis, maybe from obviously a Schedule I, which complete ban, to maybe a 2 or a 3. Just to at least allow the use of medical cannabis to be accommodated, on more of a nationwide scope, given the fact that the ADA is going to supersede, the vast majority of state laws. So just, I guess, to recap this slide real quick, nothing is changing in terms of medical marijuana. Employers still don't need to accommodate medical marijuana use. They could still fire someone just for using medical marijuana, and they could refuse to hire someone who may use medical marijuana. So again, fortunately, despite the fact that these rights don't necessarily exist for employees, employers do have discretion. I do think the vast majority of employers in Ohio will exercise this discretion. And what I mean by that is, employers can accommodate medical marijuana. They could say, yeah, I don't have to, but I will allow, these positions or all my employees to use medical marijuana, assuming it's prescribed. Similarly, these same employers can now, starting today, say, hey, I don't care if my employees, smoke recreational marijuana or consume cannabis products, as long as, again, they're not doing it at work, they're not bringing it to work, they're not under the influence at work, I don't care. Again, there could be carve-outs, as I said, for certain positions. So if you are a transportation type employee or again, operating heavy machinery, they might say, hey, sorry, we're going to have to continue to test and take disciplinary action for the use. But, hey, everyone else, absent those categories, you're free to do what you want on your own time. Again, that discretion does remain in place. And that's where a lot of our calls are coming into us. How can we amend our policies to really reflect this discretion that employers have? We want to implement, hey, either all of our employees can use recreational, we don't care, or we're going to have to limit the positions, that are still going to be prohibited from using marijuana. I don't think any employer is going to come right out and, change their handbook and say, all employees, we don't care if you use marijuana, feel free, do what you want. They're not going to include that language. What most employers are going to do is just simply, take testing of marijuana out of the handbook, right? They're going to remove that portion and, kind of the writings on the wall with that removal. But again, that discretion remains available to employers to kind of really choose what they want to do in terms of allowing employees to use either medical or recreational marijuana. So going forward, kind of if you are an employer on the line, kind of your homework assignment needs to be, you need to really figure out what course of action you want to take if you're an Ohio employer regarding medical and recreational marijuana, and then speak with your attorney to kind of decide what's best for you in determining what route to take, how maybe to amend your policies, how to implement drug testing policies if you don't have one. But fortunately, that discretion does remain available to employers. And we might be getting a question right now that says, hey, is there ever going to come a time when employers just treat this like alcohol and they really just don't care as long as you're not, under the influence at work or consuming at work? The answer is, I don't think we're ever going to necessarily see that legislated, at least not anytime soon. But I do think over time we will begin to shift to this, obviously, kind of statewide acceptance of its use, right? However, other states have taken measures, and we can discuss some of those here in a little bit. But other states have taken the approach of actually legislating in protections for employees to consume recreational marijuana. And what I mean by that is employers can't refuse to hire someone just for using marijuana, and they can't fire someone for using marijuana. Again, the state's actually saying you must treat this like alcohol. Obviously, there's exceptions, to the extent an employer needs to test for that product because of federal requirements or federal regulations that we're going to get to here in a moment. But otherwise, unless one of those exceptions apply, employers not in Ohio, but in other states are required to actually basically treat marijuana like alcohol use. So again, that's something we might be able to get to here in a little bit. Again, back to the employer best practices. I kind of just touched on this for a moment, but employers should be creating and amending their drug testing policies to account for what you want to do moving forward. Maybe it's just simply taking marijuana out the listed of banned substances. Maybe it is an affirmative statement that, hey, we will not be testing for marijuana use, absent maybe a workplace injury, just to ensure that you were not under the influence during that workplace injury. Again, the sky's really the limit of how you want to treat this. Just get it down in writing. And in Ohio, under Issue 2, if you don't have what you want to, how you're going to treat marijuana in a policy, and you turn around and you fire someone for, let's say, using marijuana, and you don't have a policy that prohibits its use, that employee is now going to be able to get unemployment benefits. So what I mean by that is, in Ohio now, as a result of the passage of Issue 2, if you don't affirmatively state in a policy or handbook that, hey, we're going to test for, and we reserve the right to fire you for using marijuana, then at that point, that employee gets terminated, they can go down, file for unemployment, and they're going to be awarded that unemployment because they didn't violate any policy or procedure of the employer. So if you want to refuse to hire or you want to terminate employees for their use of marijuana, again, that's going to require maybe some changes to your existing policies to ensure that is spelled out. But if you want to maybe kind of specify, hey, positions X, Y, and Z are going to be tested, but not positions A, B, and C, that needs to be stated as well. We need to be specific with these policies. I already kind of touched on the ADA, but again, in terms of the ADA, since marijuana still remains illegal at the federal level, there's no accommodation consideration under the ADA for its use for medicinal purposes. So if an employee comes to you and says, hey, unfortunately, I have this major back pain. I was in a major skiing accident 6 months ago. I have major back pain as a result. I've been prescribed marijuana for the treatment of that pain, and it's impacting my daily life. It qualifies as a disability under the ADA. The employer doesn't need to go through the process of determining under the ADA at this time. Doesn't need to go through that process of determining whether to accommodate it. Similarly, in Ohio, even despite our medical marijuana statute and despite this recreational legalization that took effect today, the medical marijuana statute actually also states you don't need to accommodate marijuana use. Issue 2 says the same thing. So even though it's legal at the state level in Ohio, you're still not going to be required, say, under Ohio's disability statutes, to accommodate either its medical or recreational use either. There are a couple caveats here to everything we just said. Everything I just said is really going to apply for the vast majority of Ohio employers. Couple caveats, however. The first being the DrugFree workplace program. So in Ohio, employers can receive discounts or premium discounts for their workers' compensation premiums to the extent they implement a drug-free workplace program. And what that means is testing and discipline for drug use. At this time, that program would still require testing for and disciplining for the use of marijuana, despite its recreational status. Now, is it possible that the Bureau of Workers' Compensation amends that rule to remove marijuana from that scheduled list? Potentially. We don't know if they're going to yet. We're still waiting to see. But if you're a subscriber to the Ohio Bureau of Workers' Compensation's drug-free workplace program for the purposes of premium reductions, you're going to want to speak to your attorney to determine to what extent you still need to be testing for marijuana. If you are sitting there wondering, am I a subscriber to this program? you're going to need to check to make sure before you make those changes to your handbook or allowing employees just to begin using marijuana. So if you're not implementing a standard testing program, you're likely not a participant in this program. But to the extent you may be, again, you got to speak with your attorney to make sure that you're actually able to now allow employees to use marijuana, given the fact that they have not yet changed those regulations. We've talked about the feds. Another caveat, too, is let's say you are an Ohio employer and you, however, have federal contracts or federal grant agreements. Those contracts and those agreements may state that you are required to implement a drug-free workplace program. And if they do, as a result of marijuana's classification of a legality at the federal level, you would still need to test for marijuana if you have a federal contract or a federal grant that requires you to. If you don't, again, everything reverts back to the freedoms to the employer to do how they choose. They have that discretion. But if you have those contracts, you have those grants, get with your attorney to make sure that any changes to your drug testing policies or procedures are appropriately amended to make sure you're not running afoul of those grants or those contracts. One question we often get is, and this is almost a presentation for a whole other day, but to what extent do Medicare and Medicaid contracted physicians, so basically you're contracted with Medicare to provide, services to Medicare patients who receive reimbursement, and the same thing with Medicaid. It's often been opined that just being a Medicare, Medicaid provider is not going to be sufficient to rise to the level of you having a federal contract. Despite the fact you've entered into a contract with the federal government, that's not necessarily sufficient. That federal contract needs to state, hey, you are required to have a drug-free workplace program. So again, just simply being a Medicare or Medicaid provider is typically not enough to rise to the level of requiring that drug-free workplace implementation. But again, if you have any questions about that, again, not legal advice, but if you have any questions about that, definitely speak with your attorney about qualifications to implement that program. Let's see. Yeah, so as we can see on the screen here now, the Ohio Bureau of Workers' Comp does require testing for, at a minimum, cocaine, marijuana, opioids, amphetamines, and PCP, angel dust, things like that. So marijuana, again, still falls under that list. Maybe that gets changed in the future. Maybe that gets changed through the state legislature process. Again, we're not sure. Kind of a wait-and-see approach there. If you are considering implementing, let's say you're sitting here through this presentation and you're like, you know what, I have never actually done a drug testing program, but I would like to start. Maybe you're going to remove marijuana from that program. Maybe you're not. But if you would like to implement a drug testing program, that's something, again, that should be done in conjunction with your legal counsel or employment advisor to ensure that proper rules are followed. There is significant case law on there that deal with invasion of privacy concerns that require certain procedures when you're actually conducting drug testing. Most employers utilize a third-party agency to implement those drug testing. That third-party agency is able to collect the medical records of that patient, to the extent they're going to test positive for a pharmaceutical drug that could, trigger one of the other classes. They're going to be able to show that prescription to that company and kind of keep the employer out of the business of the employee. So their medical information is still going to kind of be protected from the purview of the employer. So there's a lot of privacy concerns that come along with drug testing. So make sure if you are going to be implementing a drug testing program that you do that in conjunction with your attorney or employment advisor. Another question we often get is the use of state professional boards, and to what extent I guess Ohio licensed employees, to the extent you're required to have a license to perform your job, can use marijuana. I will tell you, I know the Ohio Supreme Court, for who have jurisdiction over attorneys, not recently, I guess it was a couple years ago, took up the question of whether Ohio licensed attorneys could use medical marijuana. And the reason is attorneys have this requirement that you have to follow all state laws and federal laws. So using medical marijuana in Ohio would be legal at the state level, assuming you're prescribed. However, you'd be running afoul of federal drug laws, right? Because you're now consuming a Schedule I unprotected drug. And so the Supreme Court ended up opining, basically saying that it depends on the facts and circumstances of the case, to the extent that, and I don't know if they ever actually heard any cases of attorneys using medical marijuana, but basically what they were saying was, to the extent it's kind of prescribed, maybe they're going to kind of look the other way at it. But to the extent, you shouldn't have that card and you have it anyway, or you are, traveling with marijuana in violation of, TSA or other federal commerce laws, or purchasing it across state lines and bringing it back. To the extent you take an extra step beyond just using medical marijuana that you obtained in Ohio, then they're going to reserve some right there. But it was a very wishy-washy decision, and I'll say there's even less clarity than that with other professions such as physicians. One of my colleagues, she does a great job speaking on the use of marijuana by licensed physicians, for example. And hopefully I'm remembering this part right. But essentially, what she says as more of the healthcare attorney is, as long as you're, again, not showing up to work intoxicated or under the influence, most professional boards are going to treat it kind of like alcohol. They're really not going to intervene in the use of that marijuana until it becomes an issue for a patient. But the advice here, right, is to never let that become an issue for a patient. Never let a situation arise where, you're using marijuana at work or accused of using marijuana at work, and that has unfortunately resulted in an adverse outcome for a patient or someone else, or you have to drive for work and you cause an accident. You never want that situation to even come up. So again, that's kind of the takeaway there. But a lot of the boards really just, saying, hey, look, don't let it become an issue because we don't want to have to get involved. So that's kind of the takeaway with most of those professions. But to the extent you are a licensed profession in the state of Ohio, make sure you're checking with your board. Maybe they've released some guidance, or checking with your attorney to what extent you could be penalized or have your license disciplined or revoked for using marijuana. You're going to want to double check on that. Okay, so that is pretty much it. That I had for the presentation today. There's a couple other quick topics we could kind of touch on here. If you have any questions or anything you want to talk about or voice your opinions, definitely feel free to use the chat box. We could certainly discuss any questions, general hypothetical type questions that you may have. I did see today, I have it pulled up on a screen here, I did see today that the city of Cleveland is going to be amending their drug testing laws for city employees, and essentially doing one of the examples that I provided, which is they're providing the classifications of employees that will be drug tested for marijuana, or will have to continue to be drug tested, and kind of removing that requirement for everyone else. So basically, unless you're falling under one of those job classifications, you would be able to legally consume marijuana as an employee without necessarily facing an adverse employment action, assuming you don't bring it, consume it at work, or be under the influence at work. Again, that's a City of Cleveland policy. I know as well, just kind of generally speaking of where the legislature may go from here, I am seeing, again, I touched on this briefly at the start of this presentation, but the Ohio Senate as well has passed legislation last night. Again, that has to go over to the House for their consideration, and then maybe up to the governor for signature. But what the Senate has proposed is basically a modification to the number of plants that can be homegrown by people. Issue 2 says a person can grow up to 6 plants, or they can have up to 12, assuming there's more than one person at a household over the age of 21. So basically it's 6 plants per adult, 21 and over, at a home, no more than 12. The Ohio Senate is proposing to reduce that down to just 6 plants total per household. Again, it's also the Senate that has proposed, that we allow for immediate purchasing of recreational marijuana from the medical dispensaries. That would take effect about 90 days if the governor were to actually just sign that into law. So much shorter than the late summer, early fall projection that we have right now of when recreational storefronts will actually be open. So if you've been sitting, kind of on whether to amend policies or your procedures, as a result of there being a significant delay before recreational storefronts actually open up, you might want to get a little bit quicker of a move on those changes or those questions or those revisions because recreational purposes may actually be coming sooner than we think, potentially by early February. Actually, it would be early March at this point, so potentially by early March. And I know they had some other kind of changes they were proposing to the actual percentage of THC that can be in certain cannabis products, reducing, I think, at one point for marijuana oils, extracts. I think issue 2 says 90%. Right now, the medical marijuana law says 70%, and the Senate is proposing, at least for recreational purposes, that the THC content of those extracts can't exceed 50%. I think that is pretty much all I have, again, for my presentation. Again, just to kind of wrap things up, if you have any questions, put them in the chat box. I'll stick around as long as you guys want to discuss this topic. But obviously, big day here in Ohio with issue 2 officially taking effect today. Again, kind of the big takeaway here, the big caveat, or a big takeaway, not a caveat. The big takeaway here is that the discretion remains with the employers. Unless you're a federal contractor or have a federal grant or a participant in that Ohio Bureau of Workers' Compensation premium program, it's choose your own adventure regarding how you're going to treat recreational use of marijuana and medical marijuana by your employees. So to the extent you want to change your policies, amend your policies, put a policy in place, now is the time to do that. Again, maybe having to move a little faster now, potentially with sales going into effect in 90 days. So definitely definitely wanting to get those changes in place and get those conversations had with your attorneys. But I think that's all I got for today. Well, I really appreciate you all for joining me during this, our first Employment Law After Hours live stream. I really enjoyed this. Maybe we'll do this a little more often, especially when big employment law changes take effect. We can hop on and just kind of have quick little sessions and hang out with you all. But again, I really appreciate it, and this presentation should remain on our YouTube page, which you should subscribe to for periodic updates on employment law issues that are keeping HR professionals up at night. So this video will be on that page for you to review again if you'd like, and if you have any questions, feel free to reach out. But thank you all.